Hello everyone, welcome to Management 413, Employment Law, here at the UAB Ch School of Business. In this video, we will be covering privacy on the job using Chapter 17 of our textbook. In particular, you can see here in the outline that when we look at privacy at work, we are talking about handling records and employee information, monitoring and surveilling employees, and investigating employee conduct. More and more employers gather much information about employees and monitor their actions and investigate their wrongdoing. The volume of information has increased over the years. What are the legal limits on doing that? Certainly for public employees who get the direct protection because their employer is the government of the Fourth Amendment to the United States Constitution, which prohibits unreasonable searches and seizures. Public employers, however, do not need to establish probable cause or get a search warrant before conducting workplace searches. I think a good rule of thumb, though, is for any employer, if there's going to be anything that impinges on privacy, the actions taken must be viewed as reasonable. Do employees have a reasonable expectation of privacy? That is a very difficult question to answer in some cases. The best way to handle this in advance is to set forth in a company policy exactly what the expectations of privacy are. For example, a handbook should say that an employee has no expectation of privacy with respect to anything that a work computer might be used for. Where there is a reasonable expectation of privacy and that privacy is violated, there are a number of torts that might be available to the employee whose privacy is violated that could be claimed against the employer. And you, as the HR professional, should be aware when the employer you're working for might be the defendant in a tort lawsuit. So let's look at what those torts might be. One tort when you are investigating or monitoring or otherwise intruding on the privacy of an employee might be the tort of intrusion upon seclusion. Here are the elements of that. The example in your textbook is a department store employee whose locker was searched because the employer suspected that someone had been taking things from the jewelry department, and she felt that she had an expectation of privacy in her locker, and it should not be searched, at least when she was not there. Another possible tort would be public disclosure of private facts. The example in your textbook on page 626 is disclosure of private medical information about an employee. A third possible tort that might be brought against the employer would be the tort of intentional infliction of emotional distress. You can look for yourselves what the torts were, what the intentional infliction of emotional distress torts were in the textbook on 627, but suffice it to say that anytime the employer goes into the employee restroom and starts recording or looking around could give rise to this tort. There are a number of laws that have privacy-related provisions. You can see what they are here. Let's look now at an employee's personnel records and the expectation of privacy there. There should be some sort of policy as to the privacy of personnel records. Some states grant employees the right to review and copy their personnel files. Alabama does not have a law like that. The federal government is controlled by a federal law called the Privacy Act that governs the handling of personnel records for federal employees. If the employer is unionized, union representatives must be given access to personnel files of the members. A good rule of thumb is that it is always sensible to obtain the consent of employees prior to giving information from their personnel files to third parties. It's one thing to look at it internally, it's another to give access to a third party. I find it very difficult to find a good reason for giving access to personnel files to someone outside the organization. If there's, for some reason you might feel the need to do that, you should get the employee's consent. The Americans with Disabilities Act has some privacy themes working through there, even if the word private is not used. Uh, you might recall from an earlier class that only medical information that is job related and consistent with a business necessity can be obtained from current employees. There's an example in your textbook. Dillard's, the department store, uh, tried to ask for very specific medical information that underlaid the reason for absences from work, and they were told that that was much too specific, and they could not ask for that. HIPAA would require that any medical information be kept in a location apart from other personnel records. OSHA would be another law that would have some privacy implications. Employees and unions have the right to look at employees' medical and exposure information. If there is some possibility that employees have been subjected to a hazardous chemical, for example, OSHA would say that employees have the right to look at that information that the company might have. There are certain record keeping requirements with respect to exposure to hazardous materials as well. HIPAA, again, is primarily a privacy regulation. As noted a minute ago, it requires that health records be kept separately. It would also require that the employer train its staff on maintaining the privacy of medical records, that it also appoint a privacy officer and notify employees of their rights. Moving now to video surveillance. Everywhere you look, there seems to be a camera, particularly outdoors. In general, employers may train video cameras on their employees without legal risk, at least in open places. Where it would be illegal would be when the surveillance is on employees who are engaged in protected concerted activities. You can't train a camera on employees who are meeting and discussing the formation of a union. The best policy would be to tell your employees that they are subject to monitoring and surveillance, even if it's not required. Take a look at this simulation, Chapter 7, Question 2. The phys ed teacher who discovered that his supervisors had put a video camera in his office inside the gym locker room because they suspected him of stealing money from students. What is the appropriate response? What is the appropriate result when the phys ed teacher sues the school system? Here's a case in your book. A very small company, an insurance company in a relatively small office, put a surveillance camera in the small unisex bathroom in the office. Would that give rise to a winning case of intrusion on seclusion? Take a look at the result in that case. There is another federal law that might govern when employers are thinking about electronic surveillance, electronic intercepting of employee communications, the Electronic Communications Privacy Act. This law makes it illegal intentionally to intercept an employee's communication and to then turn around and disclose that. There is a distinction between intercepting and accessing under this law. I'm not going to test you on that, but suffice it to say that it would be illegal to intercept a real-time conversation going on in the hallway using some sort of sound magnifying device. It would be legal, however, for your employer to look at your emails on the company email system. I think it's fair to say that the law on the privacy of the workplace is in flux. There have been a number of recent cases that have gone in favor of the employer and against the employee. There's a recent case that you can read about in your textbook that says that there is now a community norm for employers to monitor their employees' computer uses. Look at the case on page 646 of your textbook, where the question was whether an employee has a reasonable expectation of privacy as to the contents of a laptop used at home that was owned by the employer. Here's an interesting case under social media. Nurse was suspended with pay for making an offensive post on Facebook, and she tried to sue under a federal law called the Stored Communications Act, and she lost. Moving now to investigations of employee conduct, which can intrude on their privacy. We've talked about several of these topics before. If you're going to conduct an investigation, it should be done professionally, of course. But what we've talked about before is the Fair Credit Reporting Act. When we were looking at the hiring of new employees, that law would say that an employer may use outside investigators to investigate suspected employee misconduct. Presumably, they'd be looking into their credit worthiness. But that law would say that if an adverse action is taken based on that information, the employer has to disclose it to the employee. Privacy torts that we talked about before, when a company is surveilling with cameras perhaps, intrusion on seclusion, those same torts would apply in investigations potentially as well. So the best policy would be to advise employees ahead of time of when there might be some sort of search or investigation. If you are going to do a search, they should be done reasonably, professionally. No employee property should be destroyed in the process. Any evidence should be handled carefully, kept in a secure location. And I think it goes without saying that I can think of almost no situation where a strip search would ever be legally defensible. Interrogations and interviews. Sometimes they are necessary, for example, when there has been an employee theft. You give rise to the risk of some torts, such as false imprisonment, if you are holding an employee against his or her will, intentional infliction of emotional distress. Unionized employees can have their union rep in the interview in most cases. Look at the case in your book, Dietz versus Finley Fine Jewelry. An employee brought a defamation case. She had been suspected of theft and she was interviewed, but the interview was handled so badly and in front of other people that the court held that she could go to trial on her defamation claim. We've talked about this before as well. Polygraphs, that is sometimes called lie detectors, are prohibited for pre-employment situations. For current employees, they are permissible in certain limited circumstances for ongoing investigations of theft, embezzlement, sabotage, and things like that. But even in those situations, an employee cannot be disciplined or discharged for failing to agree to one of those. During a polygraph exam, the questions cannot be designed to degrade or needlessly intrude on the privacy of the employee. They may not be asked any questions about religious beliefs, opinions about racial matters. Employees should have the right to review questions beforehand as well. Once an investigation of any type is concluded, the risk can always be that a defamation suit might be brought if there are statements made that are not true. The recommendation for a best treatment would be to keep the results of investigations extremely private. That is it for this set of slides. In our next and last learning module, we will look at the subject of terminating individual employees.